Yes.
Lord, I understand that Opus haven't been able to remedy the problem.
No, so I understand.
I apologise for that, but hopefully overnight it can be resolved. Now, just dealing with one point of housekeeping, and that was the schedules to the generic particulars. I was right in two respects. First, that they exist, and secondly, they're not in the bundle. They're not in the bundle, as I understand it, because they are Excel spreadsheets.
Yeah.
And they're quite voluminous. We have, if my lords want to see them, an example front sheet from one of them. I can show you, if you wish, the order that is on a Judge Worster.
No, I don't think we need to see the order. I mean, speaking for myself, I'd like to see simply a sample page to see what is added from the... we've got the endless schedules from the points of claim, and I had assumed, because we didn't have anything else, that was it. So if there is a sample page...
Now, this is the schedule relating to the BMW, so it might be Mr. Popplewell has more to say about this than me, but my lords can see that it has the claim reference number, claimant's name, date of birth, address, postcode, vehicle registration, the credit agreement number, the vehicle make, model, and the agreement start date. And all this was done pursuant to an order made by His Honour Judge Worster. We don't need to look at it, but it's supplementary bundle, tab 26, page 274, paragraph 5.
Supplemental bundle page.
Supplementary bundle, tab 26, page 274, paragraph 5. Now, we were before lunch looking at the way in which the claimants have positioned their case in front of His Honour Judge Worster, and I'll then come on to look at the judge's distinction between a very clear case and everything else. The judge then also went on to draw a distinction between what he termed, quotes, broad common issues and, quotes, specific common issues. And it is respectfully suggested, consistent with the conversation I had with my lords this morning, that there was no solid foundation on which the judge could discern that there would be any specific common issues. And indeed, no such contention was put forward by either party. And we would respectfully say that's hardly surprising in circumstances when no such issues had been pleaded out or indeed identified by the claimants. Now, I want to look, if I may, at what the judge termed the, quote, broad common issues. And we would respectfully say that this language of broad common issues rather highlights the lack of precision in the approach the judge took when it came to identifying a common issue of fact or law that could apply across the whole cohort of cases. The judge's starting point appears to have been that he did not in fact need to identify with any specificity the common issue of fact or law that arose. And it was enough that he could say that there was a, quote, broad common issue. And the judge seems to have taken comfort from the fact that he needn't identify the precise issues because of what he considered Mr. Justice Trower had said in a case called Moon and Link Fund Solutions, which the judge referred to at paragraphs 37 and 76 of his judgment. Now, I don't want to get too much into all this, but the short point is that Mr. Justice Trower in Moon did not say that all that was required was to identify the broad common issue. What Mr. Justice Trower instead drew a distinction between was the identification of the issue, which was required, and the formulation of the specific questions to be determined at trial, which was not required. And we don't need to turn it up, but that is in Authorities Bundle, Volume 3, tab 36.
Moon is, I think I'm right in saying, a GLO case.
Correct.
So it's nothing to do with
Nothing to do with this.
ordinary civil litigation.
No.
What was the other paragraph? 37. What was the other paragraph in Mr. Justice Ritchie's judgment?
76.
76.
Just in my laws want it. Moon is Authorities 3, tab 36, and it's page 887 at paragraph 43. So we say that the judge started out in the wrong place anyway on this. And then when it comes to the two broad common issues that he identified, they were first whether there had been a regulatory breach under Conk, and second, whether the motor finance companies were liable as principal under Section 56 of the Consumer Credit Act for the dealers' antecedent negotiations. And I want to look briefly, if I may, at each of those in turn. So starting first with the issue of regulatory breach under Conk. Now, we would respectfully say there are a number of problems with this. But the first and most obvious problem...
So where are these two findings? You're saying these are the findings of broad common issues?
Yes. Let me just check. It's paragraph 76 again, I'll just check.
76.
I'm going to check that.
72.
72, I'm told, sorry. So it's page 454. Yes.
So you say, because I mean, on the face of it, when I read this, I didn't discern actually very much difference between some of this and some of what Mr. Justice Worster said, even though, sorry, His Honour Judge Worster said, even though by this stage, Mr. Justice Ritchie is re-exercising the discretion. He seems to agree with quite a lot of what Judge Worster said. But, okay, so 72 is the start.
72 is where he identifies the broad common issues. And he then goes on.
The first is Conk, that's the end.
That's in 72,
Yeah.
fifth line down.
Yeah.
And then section 56 is para 74. 73, he dismisses the in-principle approach, which we looked at or discussed before lunch.
Yeah. So the first is at 72, the second is at 74.
74, sorry, 74.
And he dismissed at 73 the fairness in principle.
Yes. Yeah. Now, as I say, there's a number of problems with this, we would respectfully say, in respect of the first, namely Conk. This issue could only conceivably arise in some of the cases. It cannot arise in relation to the unregulated agreements, nor can it arise in relation to the credit agreements entered into during the OFT period, when the Conk provisions did not apply. So to that extent, the issue, if it existed at all, was not common to all the claims. It only related to one of the three buckets I identified before lunch. The second point is there was in fact no common issue that failed to be determined in relation to Conk. And in identifying this as a common issue, Mr. Justice Ritchie did not specify precisely what the issue was. He simply referred in para 72 to breaching the Conk guidance. Now, there are, we would respectfully suggest, two conceivable possibilities. First, that there was some point of construction on the Conk rules, and in particular Conk 4.5.3, which Mr. Justice Ritchie thought could be usefully determined by the court, for example, as to the level of detail required to be disclosed. So a legal point about the construction of the rule. That's what option one.
Rule which? Rule which?
4.5.3,
Right.
which is the rule that His Honour Judge Worster had referred to,
Yeah.
we saw this morning. So that's possibility one. Possibility two is the judge thought there was some dispute about the application of 4.5.3R to the facts. So not a point of law, it's a point of application. Now, as regards the construction of the rule, we say that no such issue arises. And I say that because Mr. Justice Kerr has already decided in a case called Clydesdale that the rule is wide enough to require in some cases disclosure of more than the bare fact that commission would or could be payable. That decision is at Authorities Volume 4, tab 49.
Sorry, give me the reference again.
Sorry, Volume 4, tab 49, page 1261. Then I've asked the court please to read the head note for the facts and then also the first holding on the following page. Thank you.
And this argument or this reference is open to you, is it, notwithstanding the terms of the PTA?
Yes, because my ultimate punchline, my lord, on this is that the judge himself seems to have decided actually that everything would turn on the facts of each individual case. That's
Which judge?
Mr. Justice Ritchie.
Right.
What Mr. Justice Kerr decided is, in principle, that the rule was wide enough to cover more than the disclosure of the bare fact that the commission could be payable. Now, we say that's a finding of law that's going to bind any county court judge. But Mr. Justice Ritchie, in a passage I'll come to in a moment, took a very confused, if I may respectfully say so, approach to this case, where he effectively dismissed Clydesdale on the basis that it all turns on the facts. Now that necessarily begs the question, how is this then a common issue at all, even on the judge's own analysis of it? So he seems to have seen this issue as being one of, as it were, my second possibility, i.e. application rather than point of law. But if it's application, it's not, by definition, not a common issue. So, my lord, I would respectfully say this point is open to me on.
All right, fine. And I mean, we can look at Clydesdale for ourselves, can we? You say it's authority for the proposition.
I can just, I can give you the passages.
Yeah, give us the references, but we don't need to turn them up.
Fine. So it's the whole debate starts at page 1298 at paragraph. That's the road reference, sorry, 1293, page 1293, starting at paragraph 148. And it's positioned as an error of law. But if my lords in due course could read, it's a lengthy passage that goes all the way through to 194. But the punchline is in paragraph 194, but the lead up to it starts from 148. But you'll see the judge approaches it as a question of law and decides as a matter of law, Conc 4.5.3 can in principle extend to the disclosure of more than the bare fact of the commission, but it's going to be dependent on each case. Okay. And indeed, if you look at paragraph 177, that's precisely the submission that's been made effectively by the FCA, where he records there, Miss Stratton, therefore said Miss Stratton, the content of the required disclosure must vary depending on the factual circumstances. So, as it were, application will vary. As a matter of law, though, can extend beyond the bare fact. So that that's Clydesdale on that point. Mm-hmm. So we say that for any county court judge who has to determine one of these claims, the meaning of Conc 4.5.3 is settled. It can, in principle, require disclosure of more than the bare fact of the commission. But whether it, in fact, does will turn on the particular facts of any given case, which cannot, by definition, be a common issue. Now, as I said earlier, the judge's reasoning on this was, with respect, very confused. He deals with the substance of this issue in a single short paragraph, which is paragraph 81, which is Core Bundle 2, tab 26, at page 459. For paragraph 81. Paragraph 81, page 459.
Yeah.
Where he says, having submitted decisions in lead cases on common issues would not bind in the following cases. The respondent submitted that decision in Clydesdale bound the parties on 2 common issues. I do not accept that the non-disclosure issues or agency issues are fully determined by the judgment of Mr. Justice Kerr in Clydesdale. It will be persuasive, but the precise issues in that case may not be the same as the facts and matters which emerge in the claims herein. In any event, Clydesdale was a judicial review of FOS decisions, not an appeal from a judge's decision. Now, with respect, it's difficult to understand what the judge is saying here. He fails to distinguish between the issue of law resolved by Mr. Justice Kerr in relation to the proper construction of Conc 4.5.3 and the application of that rule to any particular facts. And the judge's observation that the precise issues in Clydesdale may not be the same as the facts and matters which emerge in the claims herein serves to highlight that the application of the rule will be fact sensitive and thus not a common issue at all. He then says at the end of paragraph 81 that Clydesdale was a judicial review of a FOS decision, not an appeal from a judge's decision. Now, it's not clear what point he's making here, but insofar as he's suggesting that the decision in Clydesdale on the point of law would not be binding on a county court judge, we respectfully say that's wrong in circumstances where Mr. Justice Kerr was addressing the proper construction of the Conc rule as a matter of law, and his ruling in that regard, as a decision of the High Court, will bind a county court judge. So that's the second reason why I say this first broad issue is not a common issue at all. And the third and final reason why I say that this first common issue is misguided is that in any event, compliance with Conc cannot itself be determinative of the existence or absence of an unfair relationship, as was made clear by the Supreme Court in Johnson. It's just one factor that goes into the mix. And we've already seen from the generic particulars this morning that the claimants themselves rely on regulatory non-compliance in conjunction with a number of other factors in asserting the existence of an unfair relationship. So, my lords, for all those reasons, we say this first broad common issue relied on by the judge is not a common issue at all. That then brings us on to the second broad issue, namely whether the motor finance companies were liable as principal under Section 56 of the Consumer Credit Act for the dealer's antecedent negotiations. Now, there are a number of problems with this issue too, but it suffices for present purposes to make 3 points. First, even if this issue does arise, it cannot arise in relation to the unregulated credit agreements to which Section 56 does not apply. So to that extent, at least, it's not a common issue to all the claims. Second, as with the meaning of Conc, we say this issue was determined by Mr. Justice Kerr in Clydesdale. Again, I'll give you the references if I may. It is paragraphs 314 through to paragraph 364, where he addresses this point.
And concludes
that that the antecedent negotiations in relation to the financing arrangements can be or can fall within Section 56. The conclusion is at paragraph 363 and 364.
Mm-hmm.
And then the third point is that, so as to put this point beyond any doubt, the defendants have now formally conceded the position in our supplemental skeleton argument. That's at Core Bundle 1, tab 22, page 361.
Yeah.
Paragraphs 10 and 11. Perhaps if I can ask the court just to remind themselves of those paragraphs. Page 361, paragraphs 10 and 11.
Was the Section 56 issue in play before Judge Worster?
I just need to check that for those who were there. I think it was alluded to. Introduced after the hearing. Perhaps Mr. Harwick can mention that when he,
fine.
When he
All right.
takes over.
It's paragraph 40 of the judgment, my lord, which you'll find in core bundle 3.
Yeah, I've got 40. That's dealing with 453.
It's agency, the second part.
He refers to agency,
Whilst agency is likely to be an issue,
breach of Cobb
performance is
122.
a degree of commonality.
Yeah, so not a reference to 56, but a reference to the agency point, in the judgment, I mean.
Well, yes.
Yeah. Thank you.
Now, even if there were these two broad common issues, that there's no dispute between the parties that the determination of any sample or lead cases would not be determinative of the remaining cases. Indeed, that they couldn't be, given the individualised approach required under Section 140A and Section 140B, both as to the assessment of fairness and the question of remedy. The judge seemed to envisage that the outcome in the sample claims could lead to mass settlements of the remaining claims. But with respect, that was entirely speculative and wasn't based upon any analysis of the claims in circumstances where they couldn't be, in circumstances where they weren't pleaded out. And we would say, with respect, it was not a reliable conclusion to draw, because save where clear issues of principle are involved, a decision as to fairness in relation to one particular relationship is unlikely to be of any real assistance in relation to another. That was a point that His Honour Judge Waxman had made.
Hold on. Which is the paragraph leading to mass settlement?
Paragraph 77, I think, is where he refers to that.
The hypothetical.
The hypothetical, Mr. Harwick's going to deal with, but he refers
But this paragraph 77 is the paragraph under that heading.
Yes, which we say itself is very telling. So this is all speculation. So he says alongside
I'm sorry to keep pinning you down to the judgment.
no, I understand, I apologise.
My friend's looking at paragraph 79, because page 458 is that is.
'85, I think, is the clearest explanation of it. At the end of '85, certainly it promotes settlement.
Yes.
And we will just show you, my lords, what His Honour Judge Waxman has said in a case called Harrison Black Horse, which is Authorities 1.
Well, why don't you just give us the...
Okay, Authorities 1, tab 14, page 250, paragraphs 50 and 51.
And he said...
He said that, save where there are clear issues of principle involved, a decision as to fairness in relation to one particular relationship is unlikely to be of any real significance in relation to another. And the judge's suggestion that the outcome in lead or sample cases could be persuasive in relation to the remaining cases failed to have adequate regard, we say, to the fact-sensitive nature of Section 140A claims, but it also failed to consider the equally fundamental point, which Mr. Justice Garnham and Master Davison observed in Adams and MOD, that the persuasive effect of a decision does not require or depend on it being part of an omnibus claim form. It can be as persuasive when it's a single claim. And that's a point that they made in paragraph 23 of their judgment, which is Authorities 4, tab 45. And this point about persuasiveness...
That's the point that Judge Worster made.
Yes.
In the second part of his judgment, when he talked about the better course being for some of the claims to be pleaded out and decided.
Yes. It's a point that Judge Worster had in mind, Mr. Justice Garner made. There's not a point the judge turned his mind to at all. He just seems to have thought that unless all this lot stayed together, there couldn't be this persuasiveness that he seems to envisage. But in any event, we say this point about persuasiveness does not sit easily with another aspect of the judgment, and that is this point about in principle fairness. The judge had rightly decided at paragraph 73 that it was not possible or appropriate to determine unfairness in principle. In other words, you can't just focus on the defendant's conduct and decide whether that renders the relationship unfair. And that was because, as he rightly said, you had to take into account all the circumstances. Now, one of the points that Mr. Justice Mann made in a case called Chew and Bank of Scotland, which we don't need to turn up, but for your notice in Authorities 1, tab 13, page 229, at paragraph 27, is that the whole notion of fairness or unfairness involves the impact of matters on a person. And no finding can arise without first asking fairness towards whom. In other words, the very same conduct by a defendant may impact two claimants in very different ways. So, for example, a defective level of disclosure might create a degree of unfairness, it might create a different degree of unfairness for different borrowers. And it's only once everything's been looked at in the round, in all the circumstances of a particular case, that a finding of fairness or unfairness can be reached in respect of that particular claimant. But this serves, we say, to reinforce why this whole notion of persuasiveness is unsound. You can't hypothesise about the outcome of case B based upon the outcome in case A. And a similar flaw can be seen in relation to an aspect.
Well, you might be able to, mightn't you, if you had more to go on. If there were 24 pleaded out claims, and those were decided through at a trial, then it's realistic to suppose, isn't it, that a defendant would look at that and see where the lines were, and that would then lead to the settlement of at least some of the other untried claims, just as a matter of practicality.
I mean, it's difficult
but it's based on that premise, which you say, well, that premise doesn't apply because we haven't got that. But based on that premise, would you not expect that to be a reasonable assumption for a court to make?
Well, you need some confidence about whether the 24 in my law's example actually were representative of the remaining 5,100 plus.
Well, that gives rise to another point that Judge Worster made about the complications of sampling and lead cases. I was simply working on the basis of there being a couple of dozen of these claims tried out, not as lead cases or samples, but just tried out.
Which is what Judge Worster had proposed.
Exactly. But on that basis, once that had happened, is it not, the proposition I'm putting to you, is it not realistic to suppose that hard-headed commercial defendants would then say, well, this one, and this one falls that side of the line, and this one, and this one doesn't?
Possibly not, but I don't think one can go as high as saying it's realistic. It's a possibility. I mean, but one would need to see what in fact had been decided, whether they really were points of principle, whether they turned on some particular feature of those individual 24 cases. I mean, one of the things that is really quite striking about this case, and I know Mr. Harwood's going to say something about this, is that His Honour Judge Worster managed this case, if I may respectfully say so, impeccably. He gave the claimants every opportunity, and Mr. Harwood will show you. He put in place or gave directions to put in place detailed sampling proposals to try and give the claimants the chance to show him why it was these cases could all stay on the same claim forms. And pages and pages of material were served pursuant to those sampling proposals. It's all in the bundle, I'm not going to go to it. And it's in the light of that, having, as I said earlier, managed the case for a year, at 5 hearings, His Honour Judge Worster decided these can't carry on together. Now,
he's rather sensibly retired, isn't he?
I see, right, I didn't know that, my lord. So he gave the claimants every chance. But Mr. Justice Ritchie sort of brushes all that aside and succumbs to it in a very, if I may respectfully say so, starting from the premise that we, the defendants, were at fault in not having told him what the issues were, when there's no obligation on us to do that. It's the claimant's claims. The onus is on them to justify 7.3. And then started hypothesising effectively about what these claims may or may not involve, having seen nothing at all from the pleading to justify that, and having no evidence before him to justify that.
Yes, on that point, can I just check? The stuff at 77 wasn't material that was debated. That comes from Mr. Justice Ritchie.
This is the hypothetical.
Yes.
Yeah, I mean, this was
the
him.
Percentages and whatnot.
This is all him hypothesising. And indeed, I know Mr. Harbert's going to deal with this, some of what he hypothesises about here is actually wholly inconsistent with the way in which the claimants put their case.
Yeah.
Now, this point about persuasiveness, there's a similar point that, or related point, that can be seen from the respondent's skeleton argument, and that's at paragraph 87. So, core bundle 1, tab 23, page 389. Paragraph 87, yes.
Mm-hmm.
So they say there in 87, in the case of an undisclosed DCA commission, the claimant's position is that with the initial payment and non-disclosure, the well, so to speak, would have been poisoned. In other words, they say that's going to be enough, probably, in principle, to get you unfairness. Only a very significant and relevant factor that could be put in the balance in order to justify, explain, or exculpate the conduct of the creditor or the effect of its conduct on the state of the debtor's finances. Without prejudice to the claimant's case on legal cases, non-exhaustive examples may include dishonest claimants, excessive delay, repayment and disclosure of commission, and bona fide compromise. Examples of this are likely to be rare. And you get a similar point back in paragraph 78 at the top of page 387, where they say the claimant's substantive case is that the defendant's non-disclosure of the DCA commissions is sufficient by itself to cause an unfair relationship.
Sorry, which paragraph?
Paragraph 78 at the top of page
78, sorry, yes.
Is sufficient by itself to cause an unfair relationship in the absence of some extraordinary countervailing factor. Now, there are, with respect to a number of problems with this. First, it runs wholly counter to the authorities on section 140A that we looked at earlier. There is no hierarchy of factors. You don't put everything in the scales against a defendant and see whether anything exists that can swing the balance back. Everything has to be looked at in the round. Second, it is in any event impossible to identify countervailing factors in the abstract. Each case will throw up its own particular features. Third, as I've just said, the whole notion of fairness or unfairness involves the impact of matters on a particular person, see Mr. Justice Mann in Tube, and the same factor might impact two claimants in very different ways. So it's all going to be fact-specific, depending upon all the circumstances arising in a particular case. And fourth, this argument is effectively a repackaging of the in principle unfairness point, with, in essence, the court being asked to assume unfairness based on defendant side conduct alone, unless there's some quotes, extraordinary countervailing factor. But as I said, that is not how an assessment under section 140A works. And the respondent's attempt to treat it as a tick box exercise is wholly misconceived. Now, one of the striking features or aspects of the judgment of Mr. Justice Ritchie is that the judge said nothing at all about how he saw his proposed approach of sample or lead cases accommodating the issue of remedy. And he made a passing reference to remedy at paragraph 80, Core Bundle 2, Pad 26, page 458. Paragraph 80, where he says, towards the foot of that page, about 7 lines up or so, fourthly, whilst the remedy will turn on the particular pleaded facts and matters, the common cause of action in these cases has within it significant common issues in my judgment, which, if a case managed together and determined in lead cases, would at least be persuasive and at least potentially binding on similar batches of claims, such as to lead to likely mass multi-case settlements, which will be convenient disposal. So the judge seems to have recognised there in passing, rightly we would say, that the appropriate remedy would turn on the particular facts and matters in any given case. And so by definition, that aspect at least would require an individual assessment. But that inevitable conclusion serves to highlight the flaw in the judge's overall approach, which we say is whichever way you cut it, the individualised assessments of these 5,000 odd claims will not be avoided. We say it would be necessary at the assessment of fairness stage, yet given you can't simply read across what has been determined in another case. But in any event, it would be necessary in relation to remedy, as the judge seems not to have disputed. Now, my learned friend, Mr. Kavanagh, suggests that the choice facing the court is between a single set of proceedings which are carefully managed, or the chaos, quotes chaos, as he put it, before Mr. Justice Ritchie, of 5,000 odd individual claims working their way through the county courts. But this, we say, is wrong for a number of reasons. First, it ignores the point I've already made, namely that the need for 5,000 individual assessments ultimately will not be avoided. Second, the choice is not necessarily between a single claim and 5,000 odd individual claims. The judge rightly recognised in paragraph 23 of his judgment that the claims did not need to be on a single claim form to be case managed together. Individual claims could be case managed together too, but the judge seems to have lost sight of that when he came to consider the substance of the appeal. And as I suggested earlier, just because cases can be case managed together does not render them suitable for inclusion on an omnibus claim form.
Yeah, that's obviously a different point. This point you're dealing with, you're saying that's a false choice.
Yes.
Because it's not necessarily the chaos of 5,000 individual claims.
No.
It's separate claims being case managed together.
Yes.
I think Dieselgate is separate claims.
I don't know.
Dieselgate's GLO.
Dieselgate's a GLO. I think the Grenfell claims are separate claims. Those are certainly being case managed together, but I don't know if they're a GLO.
I mean, certainly I've been involved in lots of pieces of litigation where separate claims are being case managed together.
Yeah.
And that leads on to the third point, the point I made earlier, is that the judge didn't engage at all with what His Honour Judge Worster has suggested would be the way forward had he thought there were suitable common issues. And I haven't yet shown you this passage, but I'll do so now, if we can go to His Honour Judge Worcester's judgment at paragraph 53, that's Core Bundle 3, tab 68, page 865.
Well, I think you and I have already referred to this.
Yes, I'm not sure I showed my lord it though.
You haven't shown it to us, no. But,
So he says...
quicker and simpler to determine the issue Mr. Clark had identified by hearing a handful of claims on the fast track.
Yes. And that's, as I said earlier, I mean, all the cases, all the big cases on unfair relationship, Plevin, Smith, Johnson, they've all been individual cases that worked their way out. But there are other examples too. Canada and Potter and Canada Square, an unfair relationship claim, all to do with Section 32, reached the Supreme Court, individual claim. You know, all these landmark unfair relationship claims are individual claims with points of principle that work their way up through the appellate courts. And that's exactly what His Honour Judge Worcester is referring to in 53. And the judge, Mr. Justice Ritchie, just failed to engage with that. So that's the third point. The fourth point is the county courts are well accustomed to dealing with these sorts of claims. Similar claims are being dealt with every day up and down the country. The recent civil justice statistics indicate that the county court receives about 450,000 claims a quarter, so about 1.8 million claims a year. So the number of claims we're talking about here is a drop in the ocean. They are all small claims. They form part of the staple diet of the county courts, and they would have been determined months ago on the small claims track had they been issued individually.
Months?
Yeah, years.
I was going to say.
Yeah, years.
I mean, I would have been very disappointed if they'd been individual claims that they'd not been resolved within, certainly resolved within a year of start.
Years ago. And indeed, the court may think it instructive the court may think it's instructive that it's the judges with frontline experience of these cases, His Honour Judge Worcester or Honour Judge Emma Kelly, that they are the ones who are resistant to the use of omnibus claim forms for the pursuit of unfair relationship claims. And it's worth looking at one passage from Abernethy in this regard. I know my Lord Justice Coulson was not keen to look at...
well, I just make a general point to everybody that it's unlikely that first instance decisions are going to be determinative.
No.
But if I'm not stopping anybody showing us anything, I'm just putting that out there so people use their time conveniently. So this is bundle 4.
4, tab 50. And the reason I say this is instructive, because these are the words of somebody who day in, day out is dealing with these sorts of cases. And that, I say, is instructive for the court to know what a judge sitting in Birmingham County Court considers the position to be in relation to these claims. So at page 1354, paragraph 96, Honour Judge Emma Kelly says, the courts are, however, used to dealing with high volumes of plebeian claims. Around 56,000 claims were issued between October 2020 and March 2022. There's a degree of consensus between the parties, but historically only around 8% of plebeian claims require a final hearing. Virtually all of these claims are on the small claims track. The parties' evidence includes examples of how different county court hearing centres list these small claims. Many courts have adapted some form of block listing, cognizant of the fact that many of the claims require a contested hearing.
Not
many. Yeah. The determination of around 20,000 claims across the A claims, let alone the B claims and any future claims, will undoubtedly put a strain on the court system if all were litigated simultaneously. However, the parties are required under CPR 1.3 to help the court further the overriding objective, which includes allotting an appropriate share of the court's resources while taking into account the needs of other cases and dealing with cases expeditiously and fairly. The warehousing of claims by HP, that's the claimants listers in the Abernethy case, Marcus Parker, with a view to unleashing them into the court system at the same time, risks undermining the overriding objective. It would be inappropriate if an implied threat to overwhelm the court system were to be a valid reason for granting a GLO if the claims were otherwise unsuited to that form of case management. Now, we say with respect, the same reasoning applies to the present situation, that the claimant's solicitors, Baring's law, were warehoused, to use Honour Judge Kelly's wording, the 5,000 odd claims here, rather than commencing them on an individual basis as and when they were received. That they should not be permitted to gain an advantage from that if the claims are otherwise not suitable for inclusion on an omnibus claim form. Indeed, I would just note that in addition to the claims the subject of this appeal, that Baring's Law, the claimant solicitors, have issued 148 individual motor finance unfair relationship claims against my clients. That's in our skeleton at footnote 17. And they are working their way through the courts in the usual way without any difficulty at all, as are the numerous other individual claims that have been issued against Black Horse or Close Brothers by other firms of solicitors. My Lords, for all those reasons, we respectfully say that the appeal in relation to the judge's approach to CPR 7.3 should be allowed. As the court will be aware, there's a second aspect to our appeal, namely an appeal against the case management directions that Mr. Justice Ritchie imposed, having reached his decision in relation to CPR 7.3.
Yeah.
Mr. Popplewell is going to address that aspect of the appeal, but I would just flag that my clients have addressed that aspect of the appeal at paragraphs 58 to 64 of our skeleton argument, which I don't propose to go through at this point in time.
No. All right.
So unless I can assist my Lords further, those are our submissions.
No, thank you very much, Mr. Goodall. That's excellent. Yeah. Mr. Hardwick.
My Lords, I appear on behalf of Aldermore Bank and MotoNovo Finance Limited in this appeal, and my clients are among the smaller cohorts of claimants, 29 claimants and 196 claimants, respectively, on the two claim forms. I'm very grateful indeed to Mr. Goodall and Mr. MacDonald for leading the argument on this point, and I adopt their submissions gratefully. I have 35 minutes to make some points of emphasis. And I want to start, if I may, with the claimant's so-called single simple premise, because that was the claimant's starting point, and it has had a fundamental impact on the way that the claimants have approached these proceedings. Now, Mr. Goodall took your lordships to paragraph 22 of the judgment of His Honour Judge Worster, which records the formulation of that premise at the hearing, and also to the way it was formulated in a very first skeleton. I just want to take your lordships to the claimant's formulation of the premise before Mr. Justice Ritchie for the purposes of the appeal. And your lordships will find that at core bundle, page 714.
So this isn't in the judgment?
No, this is the skeleton argument of the claimants for the purposes of the appeal to Mr. Justice Ritchie. It's 714 of the core bundle.
So that's volume.
I think it's volume 4. Volume 3.
Volume
2.
Tab
volume.
58. Sorry, I'll give you the tab and the volume number. So it's volume 2, tab 58, page 714.
Thank you very much.
And paragraph 10.
Paragraph 10. So if your lordships have that, page 714, tab 58, paragraph 10, we're looking now at the claimant's skeleton argument dated the 3rd of January 2025 for the purposes of the appeal. And what they say, paragraph 10, is the skeleton argument dated 15th of December, which you've seen, stated the claimant's position on the severance issue as being that all the claims were based on the single simple premise that the relationship between each of the claimants and the defendant arising from the relevant credit agreement was unfair to the claimant as debtor owing to the non-disclosure of the nature of the discretionary commission arrangement. Further, it stated that such proposition did not depend upon the individual circumstances in which the credit agreement was made. So just to be clear, that was the position the claimants adopted throughout the case management process, from November 2022 to the hearing on the 5th of May 23, and was maintained for the purposes of the appeal. And your lordships have just been shown the poison the well point in the current skeleton argument. And my lords, of course, and the point's been made by Mr. Goodall, the claim that it's possible to identify a single factor that renders a relationship unfair without regard to the individual circumstances is fundamentally misconceived, and it is contrary to the whole series of cases to which Mr. Goodall has taken the court this morning. And so, my lords, the lenders challenged the claimant's attempt, relying on that premise, to use CPR 7.3 to start the 5,000 plus claims on 8 claim forms at the first hearing. And 5 months after the first hearing was the 17th of November 2022, His Honour Judge Worster made a further case management order of the 15th of February 2023, which your lordships haven't seen. And it may help to see that. It's in the supplemental bundle.
Is this still your first point?
I'm moving to the sampling process, so it's effectively a second point.
And the reference you gave us?
So it is the supplemental bundle, tab 26, and it's page 274. 274.
Thank you.
And if your lordships have that, so supplemental bundle, tab 26, page 274, what we're looking at here is the order of His Honour Judge Worster on the 15th of February 2023. And paragraph 3 is what I wanted particularly to draw your lordship's attention to, where His Honour Judge Worster says the claimant shall, by the 8th of March, provide to each of the defendants detailed proposals for sampling cases, identifying the issues the sample cases are determined and why this is of benefit to the litigation overall. These proposals are to include criteria for the selection of sample cases, which cohorts its proposed samples should be taken from, when samples are to be chosen, and how the samples are to be chosen. So that was the obligation on the claimants. Paragraph 4 for the defendants to respond. Paragraph 5, Mr. Goodall just touched upon in relation to the schedules, to the generic particulars. And so what the court sees is that His Honour Judge Worster was anxious to understand.
I see. So, sorry, just to interrupt. So, actually, the additional stuff in the schedules, the dates, the agreement numbers, the identity of the vehicles, whatever, was an order from Judge Worster?
Yes. A generic particulars of claim had come in January 2023.
Yeah.
This is now the following month, and His Honour Judge Worster making this further order in relation to the further material for those schedules. But the point I was about to make was that His Honour Judge Worster was alive to the potential benefits of sampling cases. He'd done exactly that in the Kerrigan and Elevate case in 2020. He tried 12 cases out of 340. They were payday cases. And he wanted to understand what issues might then be capable of being determined. Well, the parties complied with that order, my lords, and the claimants produced their sampling proposals on the 8th of March. And if I could just show your lordships one part of that, and it's at page 63 of the supplemental bundle, and it's tab 3, page 63. And I hope that the court will see a paragraph 9 there. So page 63 of the supplemental bundle.
Yeah.
And we're now looking at the claimant's sampling proposals. And what the court will see, glancing halfway down that paragraph 9, picking up about 10 lines from the bottom, is the claimants say the sample cases should determine the issue, note in the singular, of whether the sampling defendants failed to follow the relevant guidance or breached the conc rules. They say this would be beneficial to the litigation overall, because the court would then be able to approach the question of whether there was an unfair relationship applying the finding in sample cases on the common issue again, being either non-disclosure of DCAs represented a failure to follow the guidance. So that is the common issue, effectively regulatory breach, that the claimants propose the sample cases should determine. And as Mr. Goodall indicated, each of the lenders engaged with this sampling proposal. They're all in the supplemental bundle. They're written material at the tabs 4, 5, 6, 7, 8, and 9. But again, it'll help just to turn up one document which responds, in fact, to that paragraph 9. It is page 89 of the supplemental bundle, tab 6. Page 89, tab 6. And if the court has that at page 89, halfway down page 89, paragraph 15, this is Black Horse's response, Mr. MacDonald's response, and he's taking up that paragraph 9 and says this is a further example of the claimant's failure to properly analyse and articulate the issues. The issue is said to be whether they fail to follow the guidance. This single issue in fact raises the following matters. A, there is no regulatory obligation under the Comp rules which requires a lender to disclose commission. A lender's obligation is under Comp 1.2.2. And then B, the court will therefore be required to consider whether in any given factual scenario the dealer was acting as Black Horse's agent, acting on its behalf, or simply acting for itself. So one sees actually that it was Black Horse here that first raised the lender liability issue, the second of the broad common issues. There isn't time, obviously, to go through all of this material. Mr. MacDonald goes on to suggest a better course of questionnaires, ascertaining basic information from claimants, and then potential test cases properly pleaded. I'm not going to go through that, but that's the tenor of what follows. But I did want to say, just as Mr. Goodall has explained, that the judge was wrong to state, as he did at paragraph 15 of his judgment, and repeatedly thereafter, that the lenders were refusing to say what will be an issue.
Ritchie.
That is not wrong.
The judge, you mean Mr. Justice?
Mr. Justice Ritchie. Mr. Justice Ritchie, paragraph 15, 63, 74, there is a repeated reference to the claim that the lenders failed to engage. That is not right. The process for identifying issues was ordered by His Honour Judge Worster on the 15th of February. The claimants produced their proposals on the 8th of March. The lenders produced 6 responses, 57 pages of material. And as you've just seen, it was in fact Black Horse that identified what came their second common issue, the lender liability.
And forgive me for asking, was this a sort of response in abstract, or was it a skeleton argument? No, it's a response which was then considered by the court.
Yes, yes. So these sampling documents came in March and April.
They're sui generis in the sense
Yes.
that it's proposals and response, and then the judge looked at them.
But it was actually the third raft of material, because what the judge first ordered back in November 2022 was a skeleton argument or a witness statement from the claimants explaining their proposals as to sampling. He then moves further to these specific sampling documents. There's then a skeleton argument for the purposes of the hearing on the 5th of May. So armed with all that material, as Mr. Goodall has indicated, it was the 5th occasion this matter had come before the judge, the 5th of May 2023.
And the 5th of May, was the hearing date.
That's the hearing.
8th of September
Judgment. Yes, absolutely right.
Thank you.
And what I wanted to come actually to that date, the 5th of May, because at that point in time, the claimant had just proposed one single common issue. You see the genesis of that in the sampling proposal. And Mr. Goodall has taken the court to His Honour Judge Worcester's record of that single common issue at paragraph 34 of his judgment. So the position is His Honour Judge Worcester orders the claimants to identify issues that the sample cases are to determine. The claimants come up with one issue. And the whole approach of the claimants, consistent with the single simple premise that unfairness didn't depend upon individual circumstances, has been to refute the idea that there are a range of individual points that need to be tested across common groups of fact patterns. Instead, what the claimants have done and did for the hearing was to identify just one broad common issue, which it expanded, as I'll come to in a moment. And it didn't undertake, the claimants didn't undertake any factual analysis of any cases. That brings me very briefly to the law. Mr. Goodall has covered the legal developments, in particular in Abbott and Morris. I'm very grateful, I endorse what he says. What is clear is that notwithstanding the clarification that there are no exclusionary tests, there's no test beyond the words of CPR 7.3, Morris nonetheless confirms that the identification of common issues are centrally relevant to the convenience test, paragraph 48. And what your lordships have seen in the analysis of Abbott and Morris is a sharp focus on significant common questions of fact and law, which comes back to the points Mr. Goodall was just dealing with, the two broad common issues that were identified. Now, as I said, at the original hearing, 5th of May, His Honour Judge Worster, there was just one issue, the Conk issue. Following the circulation of the draft judgment and Abbott, the claimant sought to expand that common issue to include the lender liability point and the unfairness in principle point. Essentially, the best place to pick this up is in Mr. Justice Ritchie's judgment at paragraph 72, which your lordships were looking at a bit earlier, and the way that Mr. Justice Ritchie ultimately looks at the issues. It's page 454 of the core bundle, so paragraph 72 in the judgment. He essentially sees the regulatory breach common issue 1, which he divides into two parts. You see that at the bottom of page 454. So part 1 of regulatory breach was breach of conk. Part 2 was the determination of whether that was unfair in principle. But he immediately, and quite properly, rejects the part 2 of common issue 1, the unfairness in principle, and we've debated that, and I'm not going to go back to it. So
unfairness in principle rejected by both judges.
Rejected by both. But part 2 of the first of the broad common issues, but rejected in limine.
Yeah.
So the two broad common issues before Mr. Justice Ritchie then narrow to breach of conk, part 1, and lender liability, as your lordships looked at paragraph 74 of the judgment. Which brings me to...
Which is the section 56.
Absolutely. And that brings me to the point covered quite quickly by Mr. Goodall, that those issues of law were determined in the Clydesdale case. Mr. Goodall's covered it. I gratefully adopt all he said. I agree. Just two further documents that might assist on this. First is at Core Bundle, Volume 3, tab 58, page 718. Give that reference again. So that is Core Bundle, tab 58, page 718.
So that's volume 2.
Oh, is it volume 2? Volume 3?
It's not. You said 3, but I think it's 2.
I'm so sorry.
That's right.
While you're just taking that up, we're looking here again at the claimant's skeleton argument for the appeal before Mr. Justice Ritchie, dated the 3rd of January. And they make clear what they consider the issue to be at paragraph 19. So paragraph 19, the top of page 718. Top of page 718.
Yeah.
They say the question posited by the claimants as the relevant common issue is concerned with the requirements of the relevant regulatory regime. That's to say whether such a regime required disclosure of the nature, that's the key word, of course, of the discretionary commission arrangement. Hence, as regards conk, the question posed was one of construction of the rules, just what Mr. Goodall was saying, issued by the FCA. Jumping 2 lines, hence the common question was not whether in a particular case, on particular facts, a broker had in fact breached the rules, but what were the requirements of those rules. So it was unequivocally, as Mr. Goodall had just explained, a question of construction, of interpretation of the former Conk 4.5.3, which only refers to existence, doesn't include the extra language of existence and nature that was introduced in 2021. The whole debate was, can existence include nature pre-2021, pre the reformulation of the rule? So that was the issue. And then I just want to show you how my clients responded to that issue in their skeleton argument for the purposes of the appeal. And it's just a few pages on. It's at page 780 of the same core bundle.
780.
Page 780. Page 780, tab 60. Paragraph 48. So what, and this is our skeleton argument, dated the 28th of January 2025.
So you said decided by Clyde.
We said decided by Clydesdale. We quoted exactly what Mr. Justice Carr said in paragraph 194. The 2018 version of comments, the last 3 lines, the word existence was already wide enough. That's what Mr. Justice Kerr decided by looking at all the other provisions of COMP, already wide enough, pre-2021 in some cases, and of course that case was all about discretionary commission arrangements to disclose more than the bare fact of the commission. So the point of construction that had been identified by the claimants was resolved in Clydesdale. And the claimants repeatedly complained in their first of appeal before Mr. Justice Ritchie that the lenders had made no concessions, and you'll have seen that the judge made such a finding at paragraph 75 of his judgment. That's wrong. Here was the clear concession of my clients on this issue as to the construction of COMP. The same applies for the lender liability point, section 56(2). Again, we conceded this below. That's in fact at paragraph 60 of the same skeleton argument. 63, I'm so sorry, 63 of the same skeleton, page 783. We again conceded, so it's para 63, the central legal point, considered and resolved by Mr. Justice Carr. And as Mr. Goodall has explained this morning, to put the point beyond any doubt, a formal concession was then made in our supplementary skeleton argument. And one of the points that is made, my lords, is by the claimants, is that, this is group litigation in action. This shows it working. That's wrong. My clients made these concessions in a skeleton argument dated the 28th of January 2025. That was 6 weeks after the Clydesdale decision on the 17th of December 2024, and they made those concessions because Clydesdale resolves these points of construction.
Just one point. This is not group litigation. Group litigation is where you have a group litigation order. CPR allows for group litigation. The old rules of the Supreme Court didn't. The CPR does. This isn't group litigation, properly so called.
My lord,
we may have to think of a word for it. I don't like omnibus, unlike my lord. We might have to think of a word for it, but it is not group litigation.
My lord, absolutely.
Which may be why both my lord and I have been asking questions about case management, because as you can tell, both my lord and I think that is a series of relevant considerations.
My lord, I'm most grateful.
Yeah. Anyway, we understand. I understand those points.
Coming to the board now, Mr. Goodall showed you paragraph 81 of the judgment, where Mr. Justice Ritchie states he doesn't accept that non-disclosure issues or agency issues are fully determined. And we're not aware of any unresolved issues on Conc 4.5.3 or section 56(2). But if the unresolved agency issues that the judge had in mind arise out of the Conc 1.2.2 provision, for your lordship's assistance, that's at page 42 of the joint authorities bundle, Conc 1.2.2. It was referred to, it's cited in the judgment by Mr. Justice Ritchie, paragraph 20. It wasn't referred to again in the judgment. It's the provision that a firm, so in this case the lender, must ensure that agents comply with Conc and take reasonable steps to ensure that other persons acting on its behalf comply with Conc. Now, that was not an issue in Clydesdale, that provision. So the lenders obviously can't point to decided authority on the point. But as ever, with a Conc provision, there is a distinction between its interpretation, its construction as a matter of law, and its application. As to any question of interpretation of Conc 1.2.2, the claimants don't identify any issue. They refer to this provision in paragraph 74 of their skeleton. They don't identify any issue of interpretation, nor does the judge. As to the application of the rule, that is again a fact-specific question. For example, in the Supreme Court in Johnson, the Supreme Court found in a customer-lender-dealer situation that the dealer was not the agent. there was no agency undertaken by the dealer for the customer. So in those three cases, in the Supreme Court, no agency was found. But it's a fact-specific question, obviously. And your lordships have heard Mr. Goodall pointed to the position of Vauxhall, 118 dealers across 181 claims. For Close Brothers, 140 dealers across 235 claims. So there are a huge proliferation of different dealers in these cases. But just very finally, as to the significance of Comp 1.2.2, and again, trying to understand what was in Mr. Justice Ritchie's mind that wasn't resolved, it's certainly not a significant, far less dispositive question, Comp 1.2.2. What the claimants have said in their skeleton of paragraph 74...
So which paragraph of Mr. Justice Ritchie's judgment suggests there are issues under 1.2.2?
He doesn't. He refers to it at paragraph 20 and at paragraph 81.
We can't be in an Alice in Wonderland world where we're trying to identify common issues or a judge's view on common issues by reference to something that isn't in a judgment.
All I was referring...
I mean, I appreciate you're simply trying to cover off the bases, but and perhaps we'd better hear from Mr. Cabot on that. Because at the moment, if it's not something which Mr. Justice Ritchie said was a common issue, then understanding the point about application, then it does seem to me that it's even more speculation.
Well, it's the confused passage at paragraph 81 of Mr. Justice Ritchie's judgment, where he refers to unresolved agency issues. And we're just wondering to ourselves, is that what he has in mind? Anyway, I won't carry on that. But what I will say is that by the time of the first appeal hearing before Mr. Justice Ritchie, of the common issues, so the two common issues that we looked at, the part two of common issue, that in fairness and principle, that had been abandoned. The other points had been determined. And that is why this case is so radically different to Abbott, with its 7 hard-edged, fact-heavy common issues, to Morris, where the court found it was likely that 5 significant common issues would bind. In this case, there are no broad common issues. And this explains, respectfully, a marked change in emphasis in the claimant's case. What they now say, it's paragraph 65 of their skeleton, is that their primary case is that the persuasive effect of decisions on lead cases is itself enough to meet the convenience test. That's the first time in this process, commenced in November 2022, that they've put forward...
But if it's not going to be binding, it makes no difference which context the hearing is, the issue is determined.
Well, I agree.
Okay.
I agree. But...
Just making sure I'm with you. That is what you're saying.
Well, once one has got no binding common issues, the claimants are now into the very different terrain, very different, obviously, from Abbott and Morris. They are into an attempt to identify individual issues, which are persuasive.
Yeah, no, what I'm pursuing, just niggling away at, is if it doesn't need to be binding, it doesn't compel a conclusion for any particular form of structure.
I agree.
Okay, I agree. Thank you.
What I will say is that the moment one moves away from broad binding common issues into individual issues that are only persuasive, it obviously is more difficult to satisfy the convenience test. Not because they're exclusionary rules, but simply because, as the Master of the Rolls observed in Morris, if you've got common issues that bind all of the claimants, obviously convenient. If you've got common issues that bind all or most, probably. This is paragraph 51 of Morris. If you've got no common issues that are binding, you are outside those situations. So what the claimants now do is they resort, I say, to the persuasive effect of lead cases. And that sharply raises the question, which has been debated. What is the spectrum, the various parts of which need to be tested? That's really what the persuasive case now raises. Because, of course, the courts are very familiar with the process of selecting representative samples of lead claimants, but it requires analysis of claims and it requires evidence. The claimants have not produced any evidence. They didn't do any analysis. There was not a single witness statement in the bundle before Mr. Justice Ritchie. And respectfully, there is a real tension in the claimant's case on the significance of lead cases, because on the one hand, they say, well, all the transactions are materially identical. That's para 89 of their skeleton. They say there's a material similarity in all cases. They say the relevant characteristics of the consumers are materially the same. But if they are so very similar, one wonders what is the spectrum, the parts of which need to be represented. Why is any trial a random trial, as the claimants state? Any county court claim or handful of claims is a suitable vehicle for adjudicating.
Can you give me the reference for where, I know you're tight on time, but can you give me the reference for where the claimants now identify the issues that they say should be determined?
There are various parts of what I was going to go to first is the judge's hypothetical issues. He covers 7 issues at paragraph 77.
But you gave us before you do that, you gave us a reference to the skeleton.
So the claimant's case being that it's the primary case, that it's a
Persuasive effect.
Yeah.
You say this is a new point never made before.
Yeah.
So they've moved away from the binding.
Yes, that's right. So it's paragraph 65 of their skeleton argument, page 383 of the core bundle. That's where they say the primary case is the persuasive effect on decisions on lead cases is enough to meet the convenience test. So that's the first time that position has been adopted. It demoted the binding broad common issues to a secondary case. What, of course, the claimants now seek to do is to defend the approach of Mr. Justice Ritchie by saying that there are material features that can be tested in lead cases. But again, as the court knows, there has been no analysis of the facts of any cases. Something that came up a couple of times was pre-action disclosure. And Mr. Popplewell has explained in his skeleton argument for BMW and Volkswagen that there were 591 individual pre-action requests against BMW and 624 against Volkswagen. So there were 1,200 pre-action disclosure requests made by bearings individually. And what is obvious with 1,200 cases is that the claimants could have done their homework. They could have batched or grouped cases, if they considered them relevant, into themes by types of commission arrangements, by amount of commission, by loan values, by common dealers, by credit history. But they didn't, because they rejected the relevance of individual circumstances. They claimed to have identified a trump card, a single criterion that made the relationships unfair. And that, of course, comes sharply to the claimants, the lender's position, the fundamental problem with a few lead cases yielding persuasive decisions. That is contrary, of course, to the law, the extremely broad, holistic, fact-sensitive inquiry mandated by the section and the case law. The myriad possible factors, the result that, even following a trial of sample cases, an individual assessment will still be required. And it comes to the nub of the problem with the omnibus claim form route, that if these continue in 12 or 18 months' time, and there's an adjudication on 9 or 15 lead cases, but the findings are not determinative on the balance of 5,000s, the very substantial risk that a significant number of cases will remain unresolved and require individual assessment. And as your lordships know, that was the real practical concern of His Honour Judge Worster. He referred to a rump of claims which were not disposed of at paragraph 27 of his judgment. That was also the point being made by Mr. Justice Garnham and Master Davidson in Adams, anticipating at paragraph 27 a cohort that would still require determination. It was also the concern of Her Honour Judge Emma Kelly. So I turn to the judges, the errors of the judge.
I'm not sure you can you? Because it's 3:20.
I had about 3 more minutes, and I just want to, I think
somebody else should deal with that. I want to stick to the timetable. If there are points that...
Yeah, if I have
I'm happy to shave off 5 minutes from my reply.
I just want to focus on...
I asked for a timetable. My TCC hat on. I expect it to be complied with. Okay, yeah, you've got 3 minutes.
3 minutes. The judge's third error of the 4 identified by Black Horse, and this was the judge's identification, his own identification of specific common issues. And the key error is at paragraph 77 of the judgment, under that heading, hypothetical, where he addresses 7 issues, 5 of which neither party had ever identified, 2 of which are the broad common issues determining Clydesdale. And just to take your lordships through that, the judgment, para 77, page 457, if you look through the points, line 5, the first specific issue that Mr. Justice Ritchie identifies is the interpretation of the wording of the DC brokerage, the main agreement, and the leaflet. Neither the claimants nor the lenders had ever identified any issues that arises on the interpretation.
Well, you made the point that none of these, except the 2 broad common issues, had been identified.
No, indeed. I mean, Barings knows these documents. It's referred in its skeleton argument to the fact that there's common wording on the leaflets. The commission may be paid. No one's raised an interpretation issue. Whether actual disclosure was provided, the second issue, the specific case of the claimants in their sampling proposal is that the disclosure of the fact or amount of commission isn't material because it's the nature that matters. So that's directly contrary to the claimant's own case. The third issue, the precise scale of interest rate discretion. Now that was a point that Mr. Justice Ritchie raised at the hearing. No party has ever identified an interest rate spread as relevant. And the claimant's case is that variations in discretionary commission arrangements are irrelevant. They say at paragraph 11 of their supplementary skeleton that the question of whether a commission is a discretionary commission arrangement is qualitative and binary rather than one of degree. The fourth issue, the relative size of the commission to the loan, that's a relevant factor to a non-DCA case. We know that from Johnson, the 55% of the total charge for credit. But again, not to a DCA case where the degree, so say the claimants themselves, is irrelevant. The fifth issue, interpretation of conc and its scope, section 56, those were the broad common issues already considered. The seventh issue that Mr. Justice Ritchie speculates about, credit history, no party had raised. So coming to the end of my submission, the judge was plainly wrong to speculate about specific issues. The burden fell upon the claimants to demonstrate convenient disposal. There was no evidence from the claimants on these points, and the specific issues identified were in important respects contrary to the claimant's own case. I'm very grateful indeed, my Lords, for your permission.
Thank you very much. Yes.
Well, as I appear for BMW Financial Services and Volkswagen.
Yes.
I'm going to address you on the case management directions. Of course, if you're with the submissions you've heard from Mr. Goodall and Mr. Hardwick, the CPR 7.3 issue and the case management directions fall away. So I'm going to proceed on the basis you're not with us. Assume, therefore, that these matters are going to proceed. I won't use the word omnibus or litigation in the superstructure.
And when you talk about the case management directions, you mean those made by Judge Worster or by Mr. Justice Ritchie?
By Mr. Justice Ritchie.
Yeah.
Which is the second part of the appeal, as it were. Is
yes.
If you're against the CPR 7.3, we say, nevertheless, the case management directions that Mr. Justice Ritchie made were wrong.
It may be that whatever we decide on the first issue, we would deal with this in any event, the case management directions. I don't think they don't necessarily stand and fall with the first issue.
Well, if you're with the lenders in the first issue, it may well be that these claims proceed by way of a single claim, because that was effective as on Judge Worster's order.
Yeah.
So one wouldn't have disclosure of all the various agreements for single claims on each claim.
No. Well, okay. So anyway, far away on his.
Can I just check? Is your desired result at the end, although you're concentrating far on Mr. Justice Ritchie, that the case management orders made by His Honour Judge Worster should be reinstated?
Yes, correct.
Right.
And not only is that our desired result, that is what the respondent's position was before Mr. Justice Ritchie. In their submissions before him, They were saying that what His Honour Judge Worster said was the better way. The references are in my skeleton, I'll take you to it in due course. It was only when His Honour Judge Worster, Ritchie, on his own motion, was minded to make these directions that the respondents at that point said, oh, actually, we do want this information. So prior to that, it was their position that His Honour Judge Worster's direction should stand. And not only that, as I'll take you to in a moment, the information or the documents which Mr. Justice Ritchie required disclosure of is actually inconsistent with how the respondents were putting their case before Mr. Justice Worster in terms of what was and wasn't relevant. The order that Mr. Justice Ritchie made, you can find at Core Bundle, Volume 2, Tab 30, page 486.
How many? 400.
486.
Thank you.
Yeah.
I'm going to be quite quick with this because I'm conscious. I think I was 25 minutes. I'm probably slightly over that.
Well, I'm certainly speaking for myself. I've read and think I follow 3.1 to 3.9.
I'm grateful. In broad terms, what he ordered was disclosure of the credit agreements, disclosure of brokerage agreements, being contractual agreements between the lenders and the motor dealers or third-party brokers, and what are called leaflets, being not lender documents, but documents by which the motor dealer or broker made disclosure to the customer.
Yes.
There was a sort of two-stage process for that. The court has heard reference to the weeding out process. His Honour Judge Ritchie built in a mechanism, Mr. Justice Ritchie built in a mechanism by which the lenders could identify which they said were DCA agreements, not discretionary commission agreements, and if the respondents accepted that, there didn't have to be disclosure, but if they didn't accept it, then there was. So it was a two-stage. And just in terms of the order, if you've read up to 3.9, 3.10 briefly, there was an oral application before Mr. Justice Ritchie for a stay, which was refused, but that was behalf of the lenders with the smaller cohorts. And then you can see at paragraph 4 that Mr. Justice Ritchie ordered generic defence from all the parties. And at paragraph 5, he provided for the claims to go back for a Coulson case management conference. He says hopefully before His Honour Worster, which given I think we just heard Mr. Justice retired, that is probably optimistic. But that was what he envisaged as the cases to go back for His Honour Worster.
Yes.
The reasons for his decision are at page 489.
Yes.
The reasons for the decision, he gave it twofold. He gave an extemporary judgment and he also gave written reasons at the end of the order that he drew up himself. You can see the written reasons at 489. And again, I'm going to try to be quite quick from this. At paragraph 2, he says that the root of the claims is discretionary commission, so it's a good idea to weed out. At paragraph 5, the reason he says he refuses to stay because the claims may have, those smaller cohorts may have within them the largest spread of discretionary commissions rates we just don't know at present. At paragraph 6, he says he's going to order disclosure of the brokerage agreement. At paragraph 7, though, he deals with the witness statement of Anne Lloyd. Anne Lloyd is my instructing solicitor. She's sat behind me today. She had put a witness statement in before Mr. Justice Ritchie, explaining the difficulties that my clients would have in obtaining both the brokerage agreements and the leaflets. Because although credit agreements are stored against the name of individual customers, brokerage agreements are not. So you can't just look up the name of a claimant, press print on a brokerage agreement. There's no software solution to obtain it. It's a manual searching exercise in each and every instance. My clients think they've got just shy of 4,000 different agreements pleaded against them. And the leaflets...
You have to do a manual search for
the brokerage agreements. Well, although there are documents, as it were, there's no easy way to find them. And they change quite regularly over time as their evidence, because there's negotiation with the brokers. The leaflets are not the lender's documents. So to obtain those, you have to contact the motor dealer, in essence, hope the motor dealer plays ball. And my clients know from their experience in individual claims proceedings in the county courts the difficulties of obtaining those documents. So that was her evidence before the judge, and the judge dismisses that evidence. And the reason he says he doesn't accept it is the witness statement of Anne Lloyd was premised on the assumption that despite a passage of 2 years and 5 months since issue, it was wholly reasonable for the defendants, in her case BMW and VW, to have done nothing so far as to seek out the relevant brokerage agreements from their own record. This is despite the fact they sensibly agree with the claimants for a schedule of claimants and CCA to be drawn up, provided a column which brokerage agreements did not contain DCs. I've seen that schedule without the DC column. It's a useful document. The claims were issued in November 22. 2 years and 5 months have passed. The only progress has been the serving of generic PAC. The defendants have had that period of time to gather together the relevant brokerage agreements, LEPAs and CCAs. The suggestions at the hearing this work would only be done henceforth, when it had not been done or even started already, was unimpressive. And that
Had your clients been under order to produce any of these before?
No. We had not only not been ordered not to do this before, it had never been requested from the claimants. The generic defences had in respect of some lenders, not all, but the material, the documentation, had never been asked. And this echoes what the judge said in his extemporary judgment, just for your records, that's Core Bundle Volume 2, tab 29, page 479.
Sorry, this echoes what?
Core Bundle Volume 2, 29479 is where the judge's extemporary judgment, the oral judgment he gave on the day, and he makes the same point with regards to the witness statement.
So this is the criticism of the defendants?
Yes, but
delay,
not
effectively.
Yes, but delay. And we say that is quite plainly not a valid criticism. The claims were issued back in 2022. I think within 3 days of receiving them, there was a hearing before His Honour Judge Worster when the issue of CPR 7.3 was in play. At that hearing, His Honour Judge Worster ordered respondents to set out their proposals for case management. At no point in those proposals did they ever say they needed this documentation. The respondents had made Part 18 requests of some lenders and had never in those requests suggested they need this documentation. Against my clients, they'd made pre-action disclosure requests, which are settled by consent, and in terms of the consent order, did not require disclosure of this document. There were sampling proposals from both parties which didn't ask for this document. And there was an issue between the parties as to weeding out. My clients still say they have, I think, about 1,800 claims being brought against them that are not DCA claims. So it's a very real issue whether those are going to proceed. It's in no one's interest for disclosure to be made against those agreements. But from the 8th of September 2023, the lenders had a judgment from His Honour Judge Worster explaining he was minded to sever/strike out all but the lead claims. And not only that, he also, in the alternative, dealt with his case management proposals if he was wrong on CPR 7.3, and didn't in those proposals at any point suggest that there should be disclosure as proposed by His Honour Mr. Justice Ritchie over the entire cohort. So in those circumstances, just imagine what the respondents would have said if the lenders had carried out that exercise and the respondents had then either, say, discontinued because of the DCA weeding out issue or had been struck out because of the CPR 7.3 issue. If they were presented with a bill in those circumstances for the search for some 5,000 different claims, and there's more agreements, they would understandably have turned around and said, well, you shouldn't have done that because we never asked for that information and you were never ordered to provide it. So we say, in terms of the criticism that the judge made about the witness statement of Miss Lloyd, that is just plainly wrong. And that is a failure to take it into account, a material consideration when the judge was making his case management.
Yeah.
You'll, of course, be familiar with the test for setting aside a case management system. So that's the starting point. He didn't have regard to the evidence before him. What he did was ordered disclosure of a large number of documents when no one had ever previously asked for it. His justification was, well, you should have done it earlier, and that doesn't stand up to scrutiny. So that's the first point. Mm-hmm. The second point is, I think I've already made the point that the respondents never asked for it. But not only did they never ask for it, in some respects, the posterior was contrary to how they were putting their case with the His Honour Judge Worster. Their sampling proposals you can find in the supplemental bundle at tab A, divided 3, page 60.
Once more, please.
That's supplemental bundle A360.
Thank you.
And that's at paragraph 6. At paragraph 6, this is the respondents, how they say generic defences should be addressed, how they were putting it before His Honour Judge Worster. And what they said is they wanted generic defences but only in respect of the larger lenders. You can see that roughly halfway down paragraph 6, the centre begin not to make any adjustments thereto. It goes, since it is not proposed. So since it's not proposed that any sample cases should be selected from the cohorts claiming as Close Brothers Limited, Startline, Motor Finance, Vauxhall or MotoNovo, those actions should be stayed at the next hearing rather than the court directing the service of generic defences by them at that stage. Once a sample case has been tried, and those stays should be lifted, at which time if the actions are not to be discontinued or compromised in light of those determinations, then generic defences might be directed, which would necessarily take account of the decisions in the sample cases and therefore be more focused. So,
Sorry, why not from those defendants?
because the respondents' proposals was the claims against them were going to be stayed.
Say again?
The claims against them were going to be stayed. That's how they were suggesting. Because they said it was smaller numbers. They said rather than having a test case involving 8 lenders, it made more sense to have test cases involving, I think they were proposing 4, whereas on Judge Worster ended up with 3. So they were proposing that Aldermore was also included because it had unregulated agreements. But
Because of smaller numbers?
Yeah, their position was it should be the 3 largest cohorts, both of my clients and Black Horse, plus Aldermore was unregulated. So that was their
So this would become sort of foot in the door litigation. You start off a whole load of claims and then you ask the judge to stay them whilst you do something else.
That was what the respondents were asking. And you will,
Yes, sorry.
you will obviously got the point that is inconsistent with the position they're now taking, which they need generic defences from everybody. Just staying with this document, if you could move on to paragraph 14.
Sorry, I've lost the page. Could you give
It will be page 67 of the supplemental.
67?
And it's paragraph 14. So it's the same document, which is the sample.
Got it.
And here the respondents set out how they propose to deal with the nature of the discretionary commission arrangement. So what they're now saying is, well, they need the sight of the brokerage agreements to know what the nature is. But that's not what they said before His Honour Judge Worster. What they said before His Honour Judge Worster was quite sensibly, there may be a small number of different brokerage types of commission arrangement. They identify 3, increasing discretionary DIC, decreasing DIC scale. But rather than needing disclosure of 5,000 or agreements for 5,000 claims, what they suggest, halfway down that paragraph, is the court should direct that sampling defendants should ensure that their sample cases reflected the variety of types of such agreements, which is an eminently more sensible suggestion than needing a very expensive and lengthy disclosure exercise. And at paragraph 16, so that's over the page at page 68, the respondents address the question of disclosure from the dealer. And of course, this is what the leaflets go to. The leaflets show what the dealers disclose. And at paragraph 16, the respondent's position is it's simply irrelevant to the claims, because the claims are brought on the premise that the nature of the discretionary commission arrangement was not disclosed. Therefore, any other disclosure that there might have been is irrelevant. So not only were they not seeking a disclosure of these documents, they were completely disavowing the relevance of the issue entirely. I think you've already been taken to what His Honour Judge Worster ordered. His Honour Judge Worster ordered a much more different approach to the judge. He ordered a targeted exercise. He was going to proceed only against Black Horse, Volkswagen, and BMW. He was going to stay the rest. He was going to weed out the non-discretionary commission arrangements. He proposed questionnaires across the entire non-state cohort. Those questionnaires were going to be used to select a pleading pool of 24, and then there were going to be 6 to 9 test cases. So His Honour Judge Worster did not envisage there being disclosure across the entire cohort. Didn't even envisage generic defences.
Can you just give me that reference again?
Yes, it's paragraphs 55 to 57 of his judgment, which you will find at Core Bundle, Volume 3, tab 68.
Don't worry, I've got the judgment separately.
Sorry, it's page 86.
It's paragraph...
It's 55 to 57 of his judgment, which is Core Bundle, Volume 3, 68, 866.
Yeah. So it's really 57.
Yeah.
And your point about that?
It's a better route, but also His Honour Judge Worster, after hearing the sampling proposals from both sides, didn't envisage disclosure across the entire cohort. Under his proposals, you would have needed disclosure from the 24 pleading pool. So individual disclosure from just 24 people, not 5,000 different claims. And no generic defences, there'd be individual defences, which are returned.
If you have sampling or lead cases, the directions are limited to the samples or lead cases. In a normal case where you order.
Correct. You don't proceed against 5,000. You proceed against the 20. You narrow it down at various different stages. You may start with the full cohort, but you don't want to try 5,000 cases. This structure. You have a pleading pool.
All right. So all of that goes to the point that you say Mr. Justice Ritchie's disclosure orders were contrary to the claimant's submissions. They were also contrary to the better way of doing it, which you say is encapsulated in paragraph 57 of His Honour Judge Worster.
Correct. And just for the references for where the respondents before His Honour Judge Ritchie were accepting that His Honour Judge Worster's orders were a good idea, you can find them all at paragraph 26 of my skeleton, which is Core Bundle, Volume 1, Divider 20, page 339.
Paragraph which?
It's paragraph 26.
Thank you.
And certainly before His Honour Judge Ritchie, there was no case management just wasn't an issue in the original appeal. There was no challenge against His Honour Judge Worster's order. They hadn't sought to appeal or suggested that was wrong in any way.
To suggest what was wrong, paragraph 57.
Yes, they didn't suggest that was wrong. Because it was only once His Honour Judge Ritchie, on his own motion, said, "I'm minded to disclose these documents," that at that point the respondents they actually would like them. But we also say, and I'm going to be quick here because I'm conscious of the time, they simply don't need them, the documents. The credit agreements they've already had. You can see from the schedule that was handed up on paper that the pleadings they've got all refer to the finance agreement. They've got the agreements. If there's one or two missing, just write in correspondence and ask for them. But I think I've already dealt with brokerage agreements and leaflets. You don't need the brokerage agreements to whittle down what these types of arrangements are. They never asked for them previously. And leaflets is contrary to their own case where they say they're irrelevant. But if you're against me, there's a more proportionate approach than ordering it across the 5,000 different claims. Order a sample of 100. Even order a sample of 1,000, which is a fifth of the cost of 5,000. I still say that would be unnecessary. But there's a much better approach. The approach from the judge was plain wrong. Very briefly, generic defences. 2 quick points here. It doesn't make much sense to take generic defences from smaller lenders if claims against them might be stayed. And that was the respondent's own proposals. The claims are not high value individually. Respondents value about £1,000 each. So against Aldermore, that's £29,000 in total from 20. Against Startline, I think the total commission paid is now 48,000. So there's not a lot of sense in ordering expensive generic defences from smaller cohorts where the costs might quickly escalate. This wasn't the approach they took before His Honour Judge Worster, and it's unlikely to add anything if generic defences are going to be produced from the larger lenders, because these are generic pleadings which are the same across the 8 claim forms. And they'll also only be generic. Contrary to the respondent's notice, these are not going to assist in identifying test claims, because the whole point of a generic defence is they're generic. So there's no individual things. As to the larger lenders, the point is a simple one. We simply query the utility of requiring a generic defence. Now, what will help, which is what His Honour Judge Worster accepted, is individual pleadings in individual cases. Those will, of course, also encompass any wider points that you would expect to see in a generic defence. And so we simply say, doesn't it make more sense to skip the expensive generic defence stage and go to pleadings the way His Honour Judge Worster was minded? And finally, in the couple of minutes I have, just a point on proportionality. The obvious point, this is going to be a very expensive exercise. It is simply unnecessary. Particularly, well, for both, the larger lenders will have the problem they've got the most claims, so it'll be a more expensive and time-consuming exercise. And for the smaller lenders, you have the point that the bill for the disclosure exercise may quickly eclipse the amount this is in issue. Mr. Justice Ritchie, in his judgment said disclosure now will not delaying disclosure will only increase costs. I can't see any basis for that. There was a couple more points in my skeleton argument. There was one on weeding out, in terms of it doesn't make any sense to have disclosure until weeding out has actually been done.
Yeah, well, you've made that point already, I think.
But other than that, we say the judge failed to take into account material considerations. The evidence before him, the orders that he made were plainly wrong. I shouldn't stand.
Yeah. Thank you very much. Mr. Finch.
My lords, I have 10 minutes on behalf of Vauxhall and Stellantis to add to what you've heard today. I'm grateful to my learned friends for their submissions. I've got them all, including Mr. Popwell's on case management. I, however, will return briefly to CPR 7.3. Having listened to the submissions of my learned friends on the unique nature of unfair relationship claims, I simply agree. Each case requires an individual and holistic assessment. It cannot be reduced to a mechanical exercise where certain issues are either individually or collectively determinative across a cohort of claims. No more needs to be said on that point, so I will confine the remainder of my time to two issues. The first is the importance of focusing on disposal for the purposes of CPR 7.3, and the second is the judge's fundamental mischaracterisation of the Finch factors.
Mischaracterisation of?
The Finch factors, my lord. I'll resist the temptation to bow.
Yeah. You won't say my factors. I would if I were you.
I couldn't possibly, my lord. I want Finch to appear in the judgment as many times as possible.
I get that. Right, so disposal.
Indeed, disposal. I note the exchange between my learned friends and the bench on the point, and I just want to add my voice to it if I may. The starting point is the language of the rule, which of course is best seen in the 2026 White Book. Under CPR 7.3, multiple claimants may use a single claim form only where the claims can be conveniently disposed of in the same proceedings. My submission is that it is not directed to whether claims can be conveniently case managed together. That is not to say that I say that case management is irrelevant. I accept that it is important. Of course, if cases cannot be conveniently case managed together, it must follow that they cannot be conveniently disposed of together. However, the other way round, the fact that it may be possible or preferable, sensible, or even the best way forward for claims to be collectively managed together weighs on neither side of the balance when deciding whether they can proceed on a single claim form. That is because you can case manage, as my lord said earlier today, 181 claims in the case of Vauxhall Stellantis as easily on one claim form as you can on 181 claim forms. The question of case management does not turn on the number of claim forms that are used at inception. It follows that it is not strictly determinative, or even, in my submission, a particularly useful guide as to whether CPR 7.3 is fulfilled. We return to the rule that refers in terms to disposal. We say then that for the use of a single claim form to be justified, the claims must be capable of travelling their entire lifespan together, from beginning to end. Final determination, and you've been taken to Abbott and Morris on that point.
They don't all have to reach the same point at the same time, or are you submitting that they do?
No, I am not, my lord, but I am saying that they would need to be disposed of or finally determined in the same proceedings.
I think I may have been at cross purposes this morning, and it may have been my fault. On the assumption that these claims are bona fide claims, valid claims, well, claims that are capable of being litigated.
Yes.
In one sense, it's always convenient for them to, it's always convenient, it may be more convenient to do other ways, to put them all in one claim form, because they can all go through, there's no impediment to disposing of them in any way at all, you've got them all in one place, if there are things. What I was getting at is and I don't know that there's a distinction between what I'm saying and what you're saying, is that one of the features that may contribute to whether it's convenient to dispose of them by way of a multiple claim form is the ease or applicability of managing the by-case management process. That's all I'm saying. Well, that's all what I thought I was saying this morning. If I said something different, I think I probably repent of it. But that's where I'm coming from. So I don't think it's a deal. I don't think it's so in the context of this appeal. I don't think it's going to influence the outcome of the appeal.
I may well have misunderstood, my lord.
Oh, well,
I apologise if that's the case.
Don't apologise.
The point.
You may well be right.
The point that I am simply making is that case management through the journey doesn't say one way or the other whether a single claim form is the right way to go.
No, but this was my last contribution. But it may facilitate disposal in such a way as to demonstrate that putting them all in together is convenient.
It may well do.
Yeah, okay.
But then I return, my lords, to the other point on which I'm not saying anything that my learned friends demonstrated, which is the holistic nature of the unfair relationship assessment. What I say about that is that if the claims inevitably or probably need to be individually determined at the end of the process, if there needs to be an individual assessment, which there does in unfair relationship claims for the reasons given, that weighs conclusively against an omnibus claim and group disposal. This was the view of Mr. Justice Garnham and Master Davidson in Adams, paragraphs 23 and 27 that you've been taken to. They say it may weigh against and the convenience may be short-lived. I go further than that and say if you can say from this point, as you can with unfair relationship claims, individual assessment will be necessary. That is mutually inconsistent with common disposal, because you are going to require an individual holistic assessment in each and every case. That is not an argument against collective management, nor is it an argument against collective proceedings, for example, under CPR 19. It is only an argument against the use of a single claim form in general civil proceedings to start multiple claims of this nature. What I say should happen is unfair relationship claims should be commenced individually on individual claim forms, brought together for common management where appropriate in the view of the presiding judge. If and where appropriate, claims can be stayed pending test cases, if true common issues can be identified by the claimants, properly satisfying the court point. And then following those test claims, you can separate the cases again onto their existing individual claim forms for their individual assessments. That avoids the difficulty, the problem, the complexity of trying to carry out hundreds or thousands of individual unfair relationship claim assessments on both principle and remedy in the same proceedings. We say it can't be done, or at least it can't be done conveniently. Finally, before sitting down, I do feel compelled to say something about the Finch factors.
Yeah.
For ease, they've been reproduced at paragraph 18 of my skeleton. You've been taken to that by Mr. Goodall. For reason of time, I will not go through them now. Suffice to say that they were advanced by His Honour Judge Worster to demonstrate the range of individual matters that may bear upon the Section 140A evaluation, and thus why these claims are distinctly ill-suited for collective determination. We can say no more than may weigh into the assessment because of the claimant's lack of particularisation. But what we were seeking to do there, what I was seeking to do there, was provide some examples of the types of things that the court would need to consider in individual claims, and indeed does, up and down the country, in individual claims on unfair relationship motor commission cases.
Yeah.
They demonstrate why individual assessment is necessary. A similar list in PPI commission claims, for example, would explain why we are still having PPI commission claims brought in the county courts today 11 years after pleading. The lists in question, the Finch factors, demonstrate why today, notwithstanding Hopcraft, Johnson and Wrench in the Supreme Court, we are still having unfair relationship claims being brought, argued and determined in different ways depending on the individual factors up and down the court in the county court. And I'll just pause there to return to two questions regarding Hopcraft this morning. The first was, why were those cases taken to the Supreme Court? I think Mr. Goodall answered this. It was because the Court of Appeal had held that the motor dealers owed their customers fiduciary duties that were breached by the acceptance of commission. That exposed the industry to billions of pounds in compensation. That was why there was the battle royale in the Supreme Court. The unfair relationship claim went along for the ride. And of course, the Supreme Court conclusively held that the fiduciary duties did not arise. The second was whether the Supreme Court was wasting its time in deciding Johnson on unfairness rather than remitting it. I would say not. The Supreme Court's approach has informed the FCA redress scheme that's referred to by the respondents. It's also being referred to by district judges up and down the country when these cases are individually determined. But what the Supreme Court's decision cannot do, has not done, and on my reading of it was not intended to do, was to determine unfair relationship assessments outside of Mr. Johnson's case, because they all inevitably turn on the individual interaction of their own facts, the holistic assessment. Returning to the Finch factors, the points of difference demonstrate the breadth of factors which ought to be considered. And it wasn't left in the ether, so to speak. Evidence was provided. That's at paragraph 19 of my skeleton, and Mr. Goodall took you to that as well. Notwithstanding that diversity demonstrated in terms of interest rates, commission levels, dealer contributions, Mr. Justice Ritchie felt that that list of Finch factors could objectively be viewed as the common factual preliminary issues provided by the defendants. With respect, that was a serious error. Asking in every claim, for example, what was the size of the commission, what was the interest rate, or what are the benefits did the claimant receive, does not create the necessary commonality. It merely identifies topics that must be examined individually in each claim. The judge's treatment of the Finch factors shows that with respect, he fundamentally misunderstood the exercise before him, both in terms of CPR 7.3 and in terms of unfair relationship assessments.
And which paragraph of the judgment do you point to in particular?
It is paragraph 63, my lord.
63.
63, where the judge, Mr. Justice Ritchie, refers to that list as the common factual preliminary issues.
Yeah.
So it shows that he misunderstood the exercise, and in my submission it reveals the same deeper problem that I previously addressed. It demonstrates...
So it's the last part of 63.
Yes, my lord. And it demonstrates the same problem I previously addressed. It demonstrates a failure to understand how this case is not about grouping together claims with common or broadly similar subjects. It's about whether unfair relationship claims can be commonly disposed of in the same proceedings. And for all the reasons given today, they cannot.
Yeah.
Unless I can assist further.
No, thank you very much. Yes.
Lords, I address you on behalf of Startline Motor Finance, a small cohort defendant. I have a very small amount of time in which to address you, so I'll jump straight in.
Yep.
My submissions are confined to the case management directions specifically as they applied to my client as a small cohort case.
These are the directions of Mr. Justice Ritchie.
That's right.
Yep.
Yes. And the cohort numbers 66 now, down from 178 at issue. It was shrunk to 66 after my clients responded back in December 2022 to a request for information under Part 18, providing commission amounts and commission models across the whole 178. The claimants then discontinued in respect of nearly 2/3 of the claims, coming down to a cohort of 66. My learned friend, Mr. Popplewell, to whom I'm grateful, has outlined to you the way the claimant's position changed in relation to directions over the course of hearing before His Honour Judge Worster, initial hearing before Mr. Justice Ritchie, then the consequential hearing before Mr. Justice Ritchie after he'd handed down his judgment. In relation to my client, at first instance, and you've seen the sampling proposals, reference for your note and for all the transcript, supplemental bundle tab 3, page 60, that they indicated that they wanted a stay and no order for a generic defence against my client. My client's response, which you'll see in the same bundle, tab 4, pages 77 to 78, indicated that we were content with that, subject to a couple of points of detail. And there
Give me that reference again, supplementary bundle.
Tab 4, 77 to 78.
Thank you.
And there was no suggestion that any additional disclosure was necessary or appropriate. Before Mr. Justice Ritchie, as you've heard from Mr. Popplewell, there was no appeal against the case management directions of His Honour Judge Worster, and indeed the indication was that the claimants were content with those case management directions. It was not until we got to the consequentials hearing before Mr. Justice Ritchie on the 8th of April, the claimants asked for generic defences and disclosure from all defendants. Their skeleton argument for that is at Core Bundle Volume 2, tab 67, pages 841 to 842. They made no reference to their position as to a stay. My client, in their skeleton argument, pointed out that there had been no change of circumstances as between the start of proceedings and that hearing, that it was disproportionate to require disclosure and or a generic defence at that stage of the proceedings, and your lordships will see that at Core Bundle Vol 2, tab 64, page 820. And it's our submission that nothing had changed, but the claimants seeing some form of tactical advantage in taking the line across the board on the coattails of what Mr. Justice Ritchie had given in his judgment. But regardless, we say, of whether it made sense in proportionality terms, particularly for the smaller cohort defendants on whose behalf I address you. What are these claims worth in financial terms? They were roughly valued at £1,000 each by the claimants when they were put in some evidence, so well below £100,000 even on that valuation. And as my learned friend Mr. Popplewell has mentioned, the total amount of commission paid in my client's case for the whole cohort, £48,000. And evidence has been put in, which is referred to at Startline's skeleton argument, which you might want the reference for, Core Bundle Vol 1, tab 19, page 324, that the cost of the disclosure exercise alone is close to the total of the amount of commission paid, and in relation to what you've heard about the obligations placed on all lenders by the judge's order, in my respectful submission, it's not a surprise that the burden of that order comes close in cost terms to the whole of the value, potential value of these claims, and of course on top of that, costs of the generic defence. And it's Startline's submission that both are wholly disproportionate, and it's our overall submission that this was a clear case where whatever the merits of the judge's decision, Mr. Justice Ritchie's decision on CPR 7.3, when he was making those consequential orders, he completely failed to consider proportionality. Certainly in respect of my clients, and you've heard the submissions of Ms. Popplewell in relation to the larger cohorts. I was going to refer to my clients as a minibus rather than an omnibus, but I gather that term isn't necessarily universal approval. Unless I can assist further, I think I might have got in within 5 minutes.
You're 5 minutes. You were 5 minutes. We're 6 minutes behind times. That's all right. We might start 6 minutes earlier tomorrow. Thank you very much. Yes, Mr. Cavender.
My Lords, this is obviously an important appeal, which will have a significant impact on group omnibus claims, particularly where such group claims involve small amounts of money, as they do here. The different forms of commission, secret or partially secret, have been charged by dealers and brokers to motor finance customers over many years. But the present claims all involve something called a DCA, or a discretionary commission arrangement. That is different, it is special, and it is pernicious, and is not something which has been dealt with in the cases we've been looking at today. And that's an important point. So in Johnson, that was not a DCA. And these kind of commissions existed where funders secretly incentivized their dealers to achieve the highest possible interest rate from customers by directly tying the amount of commission they paid to their dealers to the interest rate their dealers got the customer to pay. So the higher the interest rate the customer paid, the higher the commission the dealer broker obtained. In the result, very many customers were persuaded to pay much higher interest rates than they should have done, and that resulted in significant commissions being paid to dealer brokers. They did so in circumstances where the customers were not told two crucial things. One, that the interest rate available was not a standard rate fixed by the lender in advance, but was open to negotiation. Two, that the dealer's commission was directly calculated on the interest rate charged, i.e., the dealer generally kept the interest above the lender's lowest indicative level as commission, or at very least a high percentage of it. Now, they are particularly features of DCA commissions. Each of these 8 claim forms are intended to deal only with that type of commission. And so the weeding out is, we find any that have those particular special characteristics, they are discontinued. Now, millions of these contracts exist. Very many people still do not realise they've been victims of this sort of behaviour.
I haven't been watching television or going on the internet then. I've had 2 notifications in the last week that I have a claim, and I've never passed a driving test, and I've never owned a car.
Well, my lord, there you are. So the reach is quite significant.
Events are related.
The 2 events are related, yes.
And my lord, you're quite right. And so there has been a broad market building exercise, particularly by phone and other ways. But the central question on this appeal is whether it's convenient, in the words of 7.3, to allow numerous such claims against a single defendant. Now that's important. Each of these claims are against a single defendant. So it identifies that particular lender's and broker's behaviour. There will be enormous similarities by dint of that fact alone. About Abernethy, one of the points Her Honour Judge Kelly identified is that wasn't the case. The claimants there had enjoined a whole range of defendants on the same claim form. And so the commonality that we have here did not exist. Now, in my submission, the defendants make a range of misplaced complaints about the judgment of Mr. Justice Ritchie. But what they actually come down to when you stand back is the bold submission that the multifactorial nature of the fairness jurisdiction under Section 140A of the Consumer Credit Act make it impossible intrinsically to conveniently deal with such claims against funders on a single claim form, even if it's one per defendant. Now, they say it's intrinsically impossible, despite the fact, as we've seen, there have been examples when it has previously been done, and done successfully. So the first point is, this isn't new ground Mr. Justice Ritchie was trying to say. It had been done before. The second point, in terms of general importance here, is if my learned friend's submissions, if right, they were capable of affecting all sorts of other types of claims that might ordinarily be brought on an omnibus claim form, such as the Unfair Terms of Consumer Contracts Reg 1994, which has the same general unfairness criteria. You'll be aware from your reading that such a claim was considered in due by Mr. Justice Mann, and he considered it appropriate for an omnibus claim form. Now, the judge was clear here that it was convenient. It was convenient because it gave the court the opportunity to case manage and dispose of the numerous claims in an orderly and efficient manner. He did so on the basis of 2 broad common issues that he identified, and the use of lead cases to determine fairness and other issues on the basis they would be persuasive. We say there was no obvious mistake there, and indeed to do so was common sense. The other big picture point here is the interest of justice and access to justice. And I refer to the speech of Lord Legate in MasterCard and Merricks. paragraph 84. We've got a copy of authority we can hand. I don't think it's found its way into the bundle.
It's not in the bundle, but I think I noticed it on the bench this morning.
The paragraph is paragraph 84, my lords, where he says, especially a class regime is necessary for procedural advice, which is especially valuable where a defendant's wrongful conduct has caused harm to many people, but each individual claim is too small to justify the expense of a separate lawsuit. Without such a device, what may in the aggregate be very substantial harm is likely to go unredressed.
That's talking about class actions.
That's talking about things involving the competition law area.
Yes, but I mean, that's talking about a class action in a particular type of case. I mean, we were all, probably everybody in this room, was effectively being represented by Mr. Merricks in that claim.
My Lord,
Because I was part of the Court of Appeal, and there was some question about whether we had to recuse ourselves, and the difficulty was you wouldn't find any sentient being who hadn't had a credit card and therefore hadn't arguably paid too much. So it was decided that there was no basis on which we should recuse ourselves. But so that's a very specific. I mean, one gets the general point about access to justice, but this is a very general, a very specific point about class action.
No, it is. But what I say is that, and my lord, you've already indicated you don't yet have a name for this, but CPR 7.3 actions, omnibus, call it omnibus or not, are generally speaking part of the class action, broadly speaking, in our rules. Because 7.3 obviously is read along with 19.1. 19.1 is part of the CPR that deals with group actions. And one has to look at the two together. 19.1.
Well, 19.1 is slightly standalone before you get to the representative actions and the group litigation.
No, it is. But what it says is, I don't need to tell you what it says.
Yeah, well, it says you can have as many claimants as you like,
exactly.
and then the filter is 7.3,
correct,
if that's convenient for disposal.
Yeah. So without dancing on the head of a pin, that omnibus claim forms, for want of a better word, are part and parcel of the way of bringing multi-claimant actions. Now, the fact that it is convenient to deal with these actions in this way is underscored by the recent publishing by the FCA of their remedial scheme for DC cases, where they've considered not only that the many hundreds of thousands of these claims together, but have also imposed a structured remedy on them on the basis of a group or common basis. So when you stand back from that fact, and they've been looking at this since 2016-17, it'd be surprising indeed if the result of this appeal was that it was not convenient to dispose of these claims managed on a single claim form. And so the FCA have not only considered them, but thought they were so similar and so connected that they have granted or imposed a common remedial scheme on them. In my submission, if that were the result here, it would demonstrate a significant failing in our civil justice system to manage and deal with claims of this sort. Because my learned friend's submissions, on one view, could be summarised as it's all too difficult. My learned friend's submissions are each and every claim needs to be brought and tried on its own. And there's nothing in the CPR in terms of 7.3 or management that can avoid that conclusion. That's their stark submission. In my submission, that is plainly wrong. The other point to bear in mind here, listen to my learned friend's submissions, looking at the judge that is on the Judge Worster, which of course deserves respect, but the decision being impugned by my learned friends is that of Mr. Justice Ritchie.
Well, is it? Isn't the ultimate question that we have to decide, or the threshold question we have to decide, was His Honour Judge Worster entitled in the proper exercise of his discretion to rule that there should be individual claim forms? Because if he was entitled to do that, Mr. Justice Ritchie had no business interfering at all.
But my lord, with the greatest respect, I don't accept that. Because
There are two attacks. Sorry, there are two attacks. One is via what I've just suggested. The other is, which has been concentrated on today, is, however, even if he was entitled to have a go at what was going on, he got it wrong for the reasons that have been developed during the course of the day. But the underlying question is whether Judge Worcester's direct ruling should have been overturned.
But my lord, I don't accept that because,
Why not?
well, because if you look at the grounds of appeal, and those that were permitted and those that were not, the challenge to Mr. Justice Ritchie's impugning of His Honour's Judge Worcester's 7.3 ruling is not before you.
Well, the challenge is the exercise of discretion
By Mr. Justice Ritchie.
Yes, and on the face of it, that would involve whether he was entitled to re-exercise the discretion at all.
Well, my lord, that isn't. Can we look at the grounds of
The
appeal?
junior shakes his head. That would be a very unfortunate result if that were the case in what you have said in terrorem is an important appeal, which would have a huge effect on the conduct of this sort of litigation in terms of huge other claims, huge other types of claims, because we would then be with all kinds of hands behind our back.
My lord, yes, but my understanding of the way this appeal has...
So it wouldn't be important at all. It would be piffling, because it would be, well, the Court of Appeal couldn't do this, couldn't do that, couldn't do the other. So it's a really narrow point.
But my lord, to be frank, I don't understand what the point would then be. If you look at the grounds of appeal, can we go to those together? It's Core Bundle 1, page 21, to see what was appealed and then what was allowed.
Well, we get that, don't we, from the PTA?
We get that, well, we do, but we look at the grounds of appeal because then you can see what the points being put to me were taken and have not been allowed.
Page?
It's page 21.
Yeah.
So paragraph 1 is that Mr. Justice Ritchie applied the wrong tests, was wrong to conclude that His Honour Judge Worster had applied the wrong test.
There we are.
Not allowed to run that.
Yeah.
2, the judge was wrong to conclude the decision that His Honour Judge Worster fell outside the ambit of reasonable disagreement. So that's directly head-on challenging the decision of Mr. Justice Ritchie to set aside and for himself do the 7.3 job himself. So that is, my submission is not before this court.
Yeah.
And then
the Alice in Wonderland nature of this room full of people is made even starker, because that means that if we considered that Mr. Justice Ritchie failed to look at the detail of what Judge Worster did and failed properly to understand Morris, that wouldn't matter.
Well, it's not before this court.
Yeah, so as I say, you would say it wouldn't matter.
No. Yeah. That's why it's quite important which judgment we're focusing on. Of course, and my friends have done this in terms of advocacy, say, well, look, Mr. Justice Ritchie got it wrong because look at the sort of things His Honour Judge Worster looked at and he didn't really understand. But that's one thing. And they've been doing that, and obviously they're allowed to. But it's quite another to say, as my Lord Justice Stuart-Smith said to me, in some way the real issue is whether Mr. Justice Ritchie should have interfered with the 7.3 exercise of discretion by His Honour Judge Worster. In my submission, that's quite wrong.
Well, what do we do then if we decide that Mr. Justice Ritchie, the criticisms of Mr. Justice Ritchie are well-founded, and therefore his order should be set aside? What do we do then? Are we then entitled to say restore Worcester?
No, because
Why not?
Worster was done on that.
As a separate determination.
My lord, no, because the finding, which has not been appealed, is or cannot be appealed, is that Worster applied the wrong test. So that discretion is vitiated entirely for all time. So this court would
So
either
what do we do?
have to.
What do we do? Let's assume for one ghastly moment that we're against you on the
7.3 point.
And we say Mr. Justice Ritchie had no basis or was wrong to behave as he did. Mr. Justice Ritchie's order set aside Judge Worcester's order. If we set aside Ritchie, does not the setting aside of Worcester go with it?
You mean set aside as well?
Yeah.
When you say go with it, you mean set aside as well?
Yes.
Yes, I think a new court, whether yourself or returning it to some other court, would have to re-exercise the 7.3 discretion.
So then another court would have to re-exercise the 7.3 discretion. So 4 years of litigation would have gone nowhere.
Correct. Come back to the beginning.
Which might be a pointer to convenience.
That it's convenient not to do that, and then what Mr. Justice Ritchie did.
No, it might be a pointer that this was not a convenient way in which to run this sort of litigation, because after 4 years, nothing would have been achieved.
Well, my lord, that's rather circular argument, isn't it? I mean, in my submission, that the thought that that might be the result of this court coming to a particular view might persuade it not to come to that view.
Then that would be because the consequences, assume that we thought that a lot of the problems here were of the claimant's own making. That would then be effectively saying, well, yes, we didn't do this, or we failed to do that, and we're very sorry, whatever, but don't set aside a judgment or an order, even if you think it's plainly wrong, because of the consequences.
Well, I'm not putting it as high as that. It'd be one.
No, but that's a potential. That would be a potential result.
Well, obviously, this court, before granting any order, would look forwards and backwards to the consequences of its decision either way. And remember, 7.3 doesn't have to be the only convenient way to pass that test. It just has to be a convenient way, a point made by the divisional court in Abbott. And given the threshold my friends have to get over, which is to say that effectively Mr. Justice Ritchie was so wrong, he's out with the very generous discretion this court, in a number of authorities, I won't bore you with, you must know, allows a first instance judge case managing in a case like this.
But he wasn't a first instance judge. I mean, I get the point that you don't lightly interfere with the case managers, of course.
Yeah.
I mean, I've been saying that for a very long time, but we do have to note that this wasn't a first instance judge. This was an appeal. So this was a slightly different point, in the process, slightly different considerations apply. But I don't disagree that we have to be very careful before we think about interfering with the exercise of discretion, even second time round.
Yes, and further this, the alternative put forward before the judge at the hearing was each of these cases would be sent to the Four Winds without any management, not even before the same court. And I can show you the reference in the transcript to that, where the judge specifically asked my learned friends, what is your proposal? What do you say should happen here? And they said, nothing. They issue their claim. And remember, these claimants are not all Birmingham residents. They're from all over England.
No, Birmingham was specially chosen, as I understand it, because of their experience and expertise in managing these sorts of cases.
Correct.
And so Judge Worster was one and Judge Kelly is another.
My lord's quite right. And so the menu my learned friends had was these cases would go back to the courts of the defendants all over the country. So when we get to what do you get from the omnibus claim form, a question my Lord Justice Stuart-Smith asked a few times, what are you getting? Well, you're getting a lot. What you're getting is the collation of a number of claims, each against a single funder that has a similar, if not the same, credit agreement, similar, if not the same, brokers' agreements with a range of their brokers over time. Now, in managing that litigation, what you can do, my Lord Justice Coulson mentioned this in argument, as a matter of case management, you can make the decisions made on that claim form binding on the others. In my submission, they have to be on the claim form to readily do that. So when it's asked, what's special about an omnibus claim form, it's the organisation and it's the ability to make binding decisions that relate to the particular agreements, whether it be the broker's agreements or the credit agreements between the lender on that claim form and its brokers and the customer. And the other point that's worth mentioning in this connection is the notion that the same benefit can be obtained by just choosing 5 or 6 random cases and taking them to trial. That completely misunderstands the benefit of sampling. It completely misunderstands the benefit of deciding what range of cases can test the limits of the principle and some in the middle, to make the decision in the omnibus claim form truly useful.
Yeah. And so what are those cases? What are those claims?
Well, my Lord, that will come out in the sampling process.
4 years on.
Well, my Lord, yes.
How can that possibly be right? You were ordered to provide detailed sampling proposals. All you came up with, all your clients came up with, was there's one issue, which has now really rather fallen by the wayside. Those weren't proper sampling proposals.
Well, my Lord, if you read through them...
If you test, I agree with you, testing the limits and some in the middle.
Yeah.
Well, what are the limits? What are the claims on the limits? What are the ones in the middle?
Okay, well, this is when we get down to the information required, including the range of interest rates that were charged.
No. If you have a claim form, Mr. Cavender, under Part 7.3, you have to plead the detail of your claim. There's nothing in the civil procedure rules that say, in some way, if you've got lots of claimants, you don't have to do that.
But Lord, I'm not saying, what I am saying, though, and this is the crucial point, the engine of our case is there was a non-disclosure of this discretionary commission.
We get that.
No. We learned from Johnson, particularly, that where the interest rate is particularly, it's large, and the commission's particularly high, then that's going to be of importance. That is not something the claimants can plead until they see the brokerage agreement, which they're not a party.
We get that. But that's part of a defence to an individual claim.
Well,
these claims could have been struck out on the basis that they don't provide the necessary detail. Now, I appreciate that Judge Worster case managed them in a particular way, but as a matter of principle, there is nothing in the CPR that says if you've got 5,000 claimants, you don't plead at least some claims fully.
Well, my Lord, as you will know from your experience of group litigation, what generally happens is what's happened here, is that you issue your claim form. There are then normally case management decisions and directions, one of which is to have some kind of questionnaire, which is rather than everyone, these very small claims, pleading out a full claim the way my Lord says, is identifying some crucial information that would have been in their particular claim. And that's what His Honour Judge Worster suggested here, and is obviously sensible. So that was the route that was being gone down. So it's very difficult in my submission to now criticise the claimants for failure to plead out all the details, A, that His Honour Judge Worster didn't require by order, and B, was understood to be the subject of a questionnaire, the contents of which were yet to be agreed.
Yes, well, I get all of that, understand that submission. I think that, and we'll take this up in the morning, but I think that one of the concerns that I do have is that even by reference to the detailed order for sampling, the claimants didn't comply with that order, because we are still, nearly 4 years on, talking about things at such an abstract, notional level that it's very difficult to find any foundation to hang on to.
But when you look, and you haven't been shown those sampling documents in more detail, the main thrust from the defendant was, it's all too difficult, you need too many examples, this is not appropriate. So it was used, unfortunately.
And that could have been answered by there being what I would regard as proper sampling provisions. So we'll look at them tomorrow, but it's right that you know that certainly speaking for myself, at the moment, I am troubled that to use your expression, which I don't like, but to use your expression, an omnibus claim form has been used here to effectively avoid, for a very long period, the provision of the sort of basic information that I would have expected claimants to provide. And even if that was only done by way of samples, that hasn't happened. So that we are talking about really abstract concepts, really abstract potential issues.
Can I leave you one thought in reply, and then I'll stop.
Yeah.
The main engine of our case, what this is all about, is there's non-disclosure of a discretionary commission of a sizable amount. Those are the facts. They're the main facts. All this other information you're talking about is background and is required, but either we're right or wrong that there was a discretionary commission and it wasn't disclosed. If there was, and it was significant, it's very difficult to see how that conflict of interest and that imbalance in the relationship between the purchaser and the funder and broker can ever be mended. It's so fundamental. So look with that submission at the Finch factors, which are how much is the commission, what day, who, where. It's all background. It's relevant, but it's not going to move the dial on unfairness. No. And so it's not, the breach of the conch regulation, gets you so far, but the failure to deal with that conflict of interest inherent in what I call the pernicious commission arrangement is, in my submission, unanswerable, and that's the main point in the case. And we can't plead the extent of that until we have the broker agreement, which we don't have. And that, I'm afraid, is why, to some degree, the parties have been going round in circles. And you can't sample until you know what, in this population of claims, what the interest rate was over the basic. Did they charge 1% over the minimum, or 10 or 20? Was the commission £500 or 10,000?
It would help me if tomorrow you or your junior, I suspect, could provide us with the details of when requests were made for these brokerage agreements. Because we've been told that they had not been requested.
I don't know if that's true or not, but I can check overnight, my lord.
Well, your last 5 minutes of submissions have been...
Well, they were required, and that, no doubt, is why the judge ordered that they be disclosed.
Anyway, I for one, would be grateful for that.
My lord, yes, I'll make those inquiries.
Right, thank you very much. I think almost to the minute.
Caught up, have I?
I appreciate you've been answering questions, but it's important that we identify the sorts of things we have concerns about. So I think we've made up the time, so we can start tomorrow at 10:30.
I'm obliged.
All right.
Amen.